McNulty. I'd like to ask you some questions about the March 1st, 2006 Attorney General's delegation order entitled Delegation of Certain Personnel Authorities to the Chief of Staff to the Attorney General and the White House Liaison of the Department of Justice. The order delegated to Kyle Sampson and Monica Goodling the authority to take final action in matters pertaining to the appointment, employment, pay, separation, and general administration of various employees, including, by the way, employees in the offices of the Deputy Attorney General. Are you familiar with that order?
I am now, yes.
And when did you first become aware of that order, sir?
Best I can recall is I became familiar when there was a story on the subject in the National Journal, I believe.
What date would that have been, approximately?
Within the past month or so.
So you were unaware of that?
Well, that's my best memory of. I wasn't. I just can't remember any other time seeing it or having some connection to it.
Have you seen the order before?
Before that story?
Yes.
Again, I don't have any recollection of that.
Did you understand that Kyle Sampson and Monica Goodling ever had authority to make hiring and firing decisions in your office?
Well, that's what I've come to understand. And
you only came to that understanding after reading that article?
No. As a practical matter, I knew that with regard to how the office operated. But
well, it wasn't the way that the office operated when you were first sworn in as Deputy Attorney General. Isn't that correct? That's not how the office was conducted then, hiring and firing decisions out of your office. Correct?
Well, it's a difficult subject.
Is that correct or is that incorrect?
It's hard for me to say yes or no to because I'd have to call just exactly what was occurring at the time.
Well, let me ask you this question. Let me put it like this. When it came down to hiring your Chief of Staff, you did that yourself when you were first employed as Deputy Attorney General, correct?
Not necessarily.
Well, there was no liaison, White House liaison to the Justice Department involved in your decision to hire your Chief of Staff, Mr. Elston, was it?
I'm sorry to make this difficult. It's just that if a person
is that true or is that false?
I can't say it's true or false. It doesn't fit that way. If a person's being hired into a political position, then there's a process.
Okay, well, let me stop you. I don't want to run out of time. What is your understanding of the purpose of that delegation order that you just learned about, you say, about a month or so ago in a magazine article?
Right. So
what was the purpose of that order?
My understanding of that order is to delegate to the Attorney General's Chief of Staff and to the White House liaison the responsibility for making hiring decisions in the leadership offices at the department.
You never had an opportunity to understand why that order was in it?
I don't have any memory of knowing about that order being developed or being executed.
Does it surprise you?
It just doesn't come to my mind. Did
it surprise you back in March when you first learned about it that your authority to hire and fire within your own office had been taken away from you and given to a couple of inexperienced political appointees?
What struck me was the guidance on the control sheet, if you will, that said this is to not be circulated through the office of the Deputy Attorney General. And I still don't know to this day why that was the case. I think it was.
Were you disturbed because you were cut out of the loop, as the chairman indicated?
Well, that definitely was a concern to me when I saw that. And I've heard Ms. Goodling's explanation of it. I didn't quite understand it, and I'm still not clear as to her position on that subject. But as to what I understood it to be, it looked like it was something that wasn't going through the deputy's office for recommendation to the Attorney General, as most of our documents do. I can't say much more about it than that.
Do you have any discussions with Mike Elston about him calling the U.S. attorneys, urging them to remain silent about the circumstances of their firing?
Well, I am familiar with that issue. There's two things we're talking about here. There are some January phone calls
Did
three
he
calls.
discuss the calls before he made them?
The January phone calls I was aware of. The March phone call I was not aware of.
March phone call?
To Mr. Cummins, which was the subject of some discussion at the Senate hearing and perhaps this hearing as well.
What was the purpose?
The time of the gentleman has...
Madam Chair, this is an important issue, and I would ask unanimous consent that the gentleman be given an extra minute so that we get this clear on the record.
Without objection, so ordered. You may continue, Mr. Johnson.
Thank you, sir. What were the purpose of the phone calls prior to the testimony of the fired U.S. attorneys before this body? What were the purpose?
The phone call that was made in March was the one that occurred prior to the testimony of the U.S. attorneys, and that was a phone call that Mr. Elston made to Mr. Cummins. And he wrote a letter to, Mr. Elston wrote a letter to the Senate Judiciary Committee after the testimony of Mr. Cummins about that. He did the best he could to explain his reasoning. Senator Specter asked a lot of questions to Mr. Cummins. You have Mr. Cummins doing an inference of what he thought Mr. Elston meant, and then you have the U.S. Three other U.S. attorneys and their
What was
inference.
the purpose of the phone call?
Well, Mr. Elston would say that the purpose was to encourage Mr. Cummins to understand that there was no effort to try to release information about individuals. That, in fact, Mr. Elston explains that he was simply trying to assure folks that assure Mr. Cummins that there was no personal information or information about this specific individuals that was being released by the department.
And the earlier phone calls,
the January phone calls, so those occurred prior to the Attorney General's testimony before the Senate Judiciary Committee, long before there was any notion that any U.S. attorney would be testifying on Capitol Hill. At that time, Mr. Elston, at my encouragement, called two, I think only left a message or didn't get through a third, but called two U.S. attorneys to assure them that the Attorney General's testimony the next day was not going to get into any information about particular individuals, and it wasn't going to, some of the folks' names had never even come out into the public yet, and there was growing press interest, or there were articles starting to show up, and there was a concern that their confidentiality might be, that there may be information on them, and he was trying to assure them that that was not going to occur in the Attorney General's testimony. He was not going to speak about any particular people. We are trying to, again, stick with the original thinking of keeping the matter quiet for purposes of the privacy and the confidentiality of the individuals involved.
The time of the gentleman has once again expired.
Thank you, ma'am.